My name is Sandra Pallin, and it's my privilege to introduce the Canada panel this afternoon. I'd like to just note one change to the program, please. Professor Anna Sue was originally scheduled for a panel tomorrow, and that's been changed, and she's joining the Canada panel, so she's with us. And I'd like to refer you to the program for more detailed bios on the panels. However, I would like to introduce each before they present just very briefly. Barry Bussey is from Newfoundland, which is on Canada's beautiful east coast. He holds postgraduate degrees in political science, constitutional law, peace and conflict studies, and he's currently working on his PhD in law from the University of Leiden, the Netherlands. His career has been a combination of pastoring, private practice, general counsel for the Seventh-day Adventist Church, and since 2011 he's been vice president of legal affairs for the Canadian Council of Christian Charities. Barry is an active writer and advocate for issues on religious freedom, and we welcome him to the conference. Seated beside him is Palbinder Shergill. She was raised in British Columbia on Canada's beautiful west coast. She earned her law degree from the University of Saskatchewan, and she's been appointed Queen's Counsel, which is a designation used to recognize exceptional merit and contribution in law. Palbinder has served as the General Counsel for the World Sikh Organization for over 20 years, and in this capacity she has appeared before the Supreme Court of Canada in landmark cases, some of which she will address today. Seated beside her is Professor Anna Sue. We can't boast that Professor Sue is Canadian, but we are privileged that she has chosen University of Toronto in Canada at which to work. She was born and raised in the Philippines, where she completed her undergraduate studies in political science and law, and then clerked for the Philippine Supreme Court. She thereafter earned her SJD from Harvard, where her dissertation was awarded for Best Paper in International Law. Her research includes the law and history of international human rights law, U.S. constitutional law, and law and religion. Her research has been published in multiple law journals, and her book, Exporting Freedom, Religious Liberty and American Power, is scheduled for release in 2016. So each of our panelists will take approximately 15 minutes, after which we'll have some question and answers, and we'll start with Barry Bussey.
Thank you very much. It's great to be here. This is a wonderful privilege to be on this beautiful campus and to see what all has been happening. Of course, any of us who are involved in law and religion know about Brigham Young, and certainly know about Cole and the center and the work of his staff, Don Liu, and so forth. And so it is indeed a great pleasure to be here. Today I want to talk about, in essence, I'm going to give in 15 minutes my dissertation that I'm working on right now. I've been involved very much in a case in Canada right now dealing with the Trinity Western University case, a law school, whereby a Christian university wants to have a law school and has been receiving a lot of opposition from the legal profession and from the legal academic field. Because the university requires its students to sign what they call a community covenant, which lists the expectations of the students when they come on campus. And as part of that community covenant, which is quite actually a fairly lengthy document in comparison to what the issue is as to why individual or the legal profession is so upset about this proposal, it has to do with a statement that says something to the effect that marriage, or that they expect students to live in accordance with marriage as, or if they're married, as between a man and a woman, the traditional marriage. This, as I mentioned, is a religious school. It is the Evangelical Free Church that owns and operates the university. And it has also been involved in previous litigation back in the late 1990s and into 2001, whereby the Supreme Court of Canada had to deal with a case where They were receiving or seeking to get accreditation for their education degree, which the BC College of Teachers were rejecting accreditation, again, based on its community covenant. That went up to the Supreme Court. The Supreme Court said that there was no evidence of the students who would graduate from that program being discriminatory against students in the public school system where they would teach, that whether or not the public school students, being homosexual or members of the LGBT community, that those students who graduate from TWU would in any way discriminate. There was no evidence, and as a result, the Supreme Court of Canada ordered for the accreditation of the education program at TWU. TWU thought that when they went with the law school proposal, they've already covered this ground and thought that they wouldn't have to worry about this kind of thing again as they introduce yet another new academic program. How wrong they were. So it's been a case that's involved a lot of issues, and I know I don't have much time to get into that case per se, but what that has done is it has caused me to step back and look at the situation at hand and try to understand what's happening. Because on the one hand, one could say that there's legal precedent here for Trinity Western to receive approval for its law school program. One would have thought that the 2001 case would be precedent and would indeed govern the situation as it now faces. However, it does not appear to be something that is persuasive in a large number of legal academics and in the large section of the legal profession. 3 law societies have already decided that they will not accredit the program. And virtually every single law faculty, we have 18 common law faculties in Canada. We have universities in Quebec, but they are civil law, so they have not really spoken out on this issue. But of all of the common law faculties of law, they've all passed resolutions against the idea of Trinity Western being accredited as a law school. So my mind began thinking about what's happening here, because on the one hand, Canada has a long tradition of religious freedom. Religious freedom is protected under the Charter. We have a lot of history throughout, certainly in the modern era. When I say modern, I mean up into post-World War II, where you have a lot of case law dealing with minority groups such as Jehovah's Witnesses and so forth, who have received a very fair hand, as it were, with respect to judgments from the Supreme Court protecting religious freedom. In fact, in 2004, when the court was deciding on the marriage reference case, the court in its decision made a statement to the effect that the protection of religion is jealously guarded by the court. So one would have thought that given the position of religious freedom in Canada, that this would almost be a no-brainer. But yet there is such opposition, one wonders, okay, well, what's happening here? And so that's what I'm trying to determine. And I'm asking myself the question, what is it about religion, first of all, that has received special accommodation in the law, in liberal democratic societies? What is the essence of religion? What is it about religion that we even have a situation where one would argue that religion has received this special status? Then, whether or not this special status should continue is another question. And is it possible that we've now arrived at a situation where religion is being, or at least the Legal Academy is of the view that religion should not have this special status that it has received under liberal democratic theory? So what I am proposing in my study is look at this concept and then try to be able to determine exactly what's happening. What I argue is that in essence, we are dealing with a situation where there is a legal revolution, I suggest, at hand. I think that what we are seeing is, in fact, a recognition in the legal community that the current legal status of religion, being a protected right, receiving the special status and accommodation, may in fact now be challenged. And so we know, of course, about revolutions when we think of the religious revolutions throughout history. We can think of the Reformation that totally changes the paradigm. And I'm suggesting that one could look at, from a conceptual point of view, think of what happens in the scientific community when we have an established paradigm of understanding what the world is. And we can think about all kinds of throughout the history of science, for example, where individual scientists have had a view with respect to what the world is. We can think of Galileo and his, the putting forth the arguments of Copernicus that in fact the Earth is not the center of the universe, but it actually is going around the sun, and so forth. But yet that required a total change of mindset, a paradigm shift. Now, many scientists have often argued, well, they are scientific, they're objective, and so forth, and they're not subject to bias and all of those kinds of things. They always look at the evidence. And a study, of course, by Thomas Kuhn back in the 1960s, in which he entitled it The Structure of a Scientific Revolution, whereby he notices a number of things about scientists and about the way in which, or the anatomy, as it were, of a scientific revolution. He talks about, in his work, the concept of the paradigm and how that sets the mindset for scientists to have a particular view and how they see the world. And then in various researches, some anomalies arise. And this causes some consternation within the paradigm, but for the most part, scientists will try to explain that anomaly based on the overall paradigm. But if there's an increasing number of anomalies, then what happens is the paradigm becomes so stretched that it creates a crisis moment whereby people begin to question, well, is the paradigm actually true? And so then there's a whole discussion about that, and eventually there's a certain moment, and it's kind of like the eureka moment, where somebody, maybe that was, as he mentions in his research, some scientists would say that they were in a shower, and all of a sudden they connect all the dots and they say, aha, in fact, the quantum theory is in fact true. Einstein has his moments of understanding that perhaps Isaac Newton wasn't absolutely correct with his views on the law of gravitation and so forth, and the law with respect to light and all the rest of it. And so I'm questioning and I'm asking, has the legal profession in Canada, has the paradigm of religious freedom being such an important part in the liberal democratic theory, have we come to a point where perhaps we're now at a point where there's a paradigm shift in the making, where once religion was extremely important for liberal democracy to exist, the history, I look at the history, I look at philosophy and so forth, the importance of religion. I look at the pragmatic aspects with respect to religion. And are we now at a point where there may in fact be a legal revolution with respect to religion? And what would that look like? And so that's what I am looking at with respect to this whole question, looking at the broader impact of Trinity Western University and this particular case. Now, it seems to me that in answering the question, why religion, it occurs to me that there are three reasons as to why religion has been protected in Western liberal democratic thought and history. How am I doing on time? Am I doing okay? 4 minutes. I got to do 50 minutes in 4 minutes, so here it goes. So it's kind of like taking a drink from a fire hose, but we'll manage. My sense is that the reason why religion has been so important and protected in liberal democratic thought is because, first of all, there's a philosophical reason. As human beings, we ask big questions. We ask, where did we come from? Where are we going? How did we get here? And in all areas of human endeavor, we see those same kinds of questions being asked. We're seeing asked by what we now call scientists, but were once known as natural philosophers, of trying to figure out the whole concept and the history of mankind. Scientists today are out in outer space trying to determine the Big Bang Theory. So in our search, we also had just political philosophy, religious philosophy, and we're asking these big questions. Part of that big question, after trying to just give you the highlights as I go through here, but is the concept of sovereignty. To whom do I hold allegiance to? Who am I responsible for? In our history, we have seen that in the Roman times, the emperor was not only the temporal king, but he was also the spiritual god of the society. He was God and king. And there was this unification of the state. In fact, I suggest divinity of the state. Now, this has been challenged over through history, but in the modern age, I'll skip a whole bunch here, but in the modern age, we've also come back to the idea of the Christian concept of render unto Caesar the things that are Caesar's, to God the things that are God's. And so we got this, again, bifurcation and development of enlightenment and all the rest. So what I'm arguing is that in the midst of this revolution that's going on in the law, that what is happening when you do not allow the individual and the community that they come from to be able to establish for themselves to whom they owe responsibility, i.e. the responsibility in the religious faith, that if the state then says that you must follow what we say is the legal norm with respect, in this case, to marriage, in essence, the state is determining for the individual to whom they hold ultimate responsibility, and that, I'm suggesting, is a merging back together of the divinity of the state, which I think is very problematic in the long term for democratic society.
Thank you, Barry. That was a very hard act to follow. So I'm going to try, as the second last speaker for the afternoon, to be as engaging as I can, but I do understand that it's been a long day, so I'll forgive you for snoring, but just don't do it too loudly while I'm speaking. I want to speak about the intersection between law, religion, and social stability. And my thesis for today's topic is really going to be this issue of how do we move from religious freedoms to social stabilities? And particularly, what is the role and what are the responsibilities of religious organizations and communities? And I will do that particularly having regard to the organization that I work for, and speaking about what kind of work we do, why we do it, and whether or not that actually assists in that ultimate goal of enabling social stability or not. We heard throughout the day today, I think, a bunch of different ideas and definitions of social stability. I'm not going to focus on what I call external stability. So in my mind, social stability can take two forms. It can be internal or external. External being national issues related to security, safety, those types of things. And internal really referring specifically to issues related to social harmony. How do we as individuals and as communities build a better, stronger society so that ultimately we're able to deal with national threats? And in my view, religious communities, while they have continued to play an important role over the years, have come to a place where we have to actually reconsider the roles we've played and decide whether we are prepared to go that extra mile. And that extra mile that I want to speak about is really stepping outside of our silos in such a way that we are actually not just representing and defending those interests that we're comfortable with. In other words, looking at the other as somebody who I can potentially tolerate, and therefore I'll respect their right to wear a hijab or something else, but rather stepping forward from that tolerance to an acceptance to the point where we're prepared to recognize that that otherness may sometimes actually challenge our very question of right and wrong. And how far are we prepared to go forward even where their otherness may defy or may challenge our values and our views of what is right or wrong morally. And that's the direction in which I think Barry's speaking about to some degree on the Trinity Western issue. But I'm going to speak about it in a larger context within Canadian jurisprudence and the role that the World Sikh Organization has played in that. I think I have to begin first by perhaps giving you a little bit of an introduction. Really, who is the World Sikh Organization, and I suppose who are the Sikhs? Because I think that's an important piece of this component when you begin to look at the kind of work we're doing and why we do it. Sikhism, as many of you may know, is the 5th largest religion in the world. At least 22 million followers around the world, majority of which reside in India. And then there are large communities in the diaspora, primarily in Canada, the United States, and the United Kingdom. So in Canada, approximately 500,000 Sikhs reside there. And that relates to about 1.6% of the Canadian population, which interestingly is actually very close to the proportion that they represent in India as well, which is about 2% of the total population in India. The World Sikh Organization is a human rights advocacy group, and we were founded in 1984 in North America to represent the interests of the Sikh diaspora. And one would think that when we speak about the interests of the Sikh diaspora, that may in fact have a very narrow definition, but the WSO has really taken that in the broadest possible sense of the word to really relate to the interests of any individual that is affected in a way or discriminated in a way as a result of their own religious beliefs. And that comes from a basic value in Sikhism, which is really the principles of the faith itself. Sikhism was founded in the late 1400s by Guru Nanak, and it was really a religion that was founded to challenge the social structures of the day. Guru Nanak perceived the world and certainly society around him as being intrinsically in disrepair, primarily because of religious conflict, and felt that religions were in fact playing a very detrimental role towards this whole idea of social stability, when in fact they should be building society. And so a large part of his impetus was to really challenge existing social mores. Whether or not it was issues related to female infanticide, which he stood up against, whether it was issues related to gender inequality, caste system, the very distinct divisions between different religions. Sikhism as a philosophy believed that every single religion is a pathway ultimately to the same goal. That whether you're a Sikh, whether you're a Hindu, whether you're a Muslim or a Christian, if you're true to your own faith, then you will ultimately reach the same goal. And for a Sikh, that goal is important because I think it'll resonate for each of you that comes from different faith communities. But ultimately, the goal for a Sikh, spiritual goal, we view is simply conscious union with our divine source. And so we believe that the way to have this conscious union with our divine source is to really act in a godlike way. And so how does one behave in a godlike way, or in a way which represents and reflects this creative harmony? And the way that Guru Nanak approached this was that he began with this premise that all dissension in society is caused really by by duality, this sense of me and not me. So this idea that this whole world is created of two types of entities. There's I, which means everything to do with me, whether it's my family, whether it's my friends, my things, my belongings, and everything else outside of that is seen to be not me. And when we begin to see the world in that parsed out way, Sikhism and Guru Nanak believed that that really was where we started to create dissent. We started to create problems, because the minute I see you as the other, then your problems don't become mine. Then I'm not prepared to go that extra mile for you. I'm not prepared to step outside of my comfort zone to assist you. And so he felt that if you ended this duality, if you ended up with this concept of unity, this unity, oneness of humankind, this brotherhood of man, of woman, of society, then you would begin to be able to view the world as intrinsically connected and interconnected with each other. And if we were able to get rid of this duality, then we would be able to create a socially harmonious, socially stable society. Which is all well and good in a theoretical way, but how does one achieve that in a practical way? And so for Sikhism, the practical way was to literally walk the talk. So Guru Nanak taught, and Sikh philosophy really teaches, that if you want to create the change, then you have to be the change in a very simple, straightforward way. So how do you do that? Well, part of what you have to do is you have to be prepared to make yourself really uncomfortable, to the point of self-sacrifice. And that's partly why our 9th Sikh Guru, because Sikhism evolved over 200 years, and the final form was in 1699 with the creation of a separate Sikh identity. But the 9th Sikh Guru actually chose to be beheaded by the Mughal rulers of the day in order to defend the rights of the Hindus to freely practice their faith, because they were being forcefully converted by the ruling Mughals. And so because this Sikh Guru chose to step up, sacrifice his life for the sake of not his own faith, of his own people, but for a different people, but in his mind, those different people were still his people, because that distinction between myself and the other was no longer there. And I think when we look at the kind of work that religious communities are doing, we always have to ask ourselves that same question. Are we really simply creating further distinctions and divisions in society? Or are we actually assisting to erode those distinctions and divisions in such a way that we can build social stability? So when WSO was faced with this issue, we simply came back to the basic idea that we have a social, moral, ethical obligation to stand up for those that may differ in their views from us completely. That's why the World Sikh Organization took a step forward and defended the rights of a young Scottish boy because he wanted to wear his kilt to graduation. And he wasn't being permitted to do so because we felt that that was something that was important for this young man to express his cultural identity. Or we spoke up in support of a young woman who wanted to play soccer wearing the hijab. Or in support of a young Aboriginal boy who wanted to keep his braids in school, but the school was forcing him to remove his braids. These were issues that we were confronted with as an organization, and in each instance we had to make that decision of, do we step outside of our comfort zone? And in every instance the answer had to be yes, because that's really where our duty lies, I think, as religious organizations. So how that translated itself in the lawmaking sphere, the first intervention we had was a case called Syndicate Northcrest versus Emsalem, where Mr. Emsalem was a Orthodox Jewish man who wanted to build a sukkah hut on his balcony for 9 days of the year for a religious celebration. But the condominium complex in which he lived in Montreal barred him from doing so. They came up with all sorts of excuses, but ultimately it simply came down to they didn't like this structure that they felt was unattractive in a very rich, expensive area. And so WSO made the decision to intervene in that particular case before the Supreme Court of Canada because we felt that there were very important critical principles that needed to be outlined and needed to be addressed by the court. Although Mr. Emsalem was not a Sikh, and Jewish beliefs are different than Sikh beliefs, ultimately the belief system really sits down to the same values of making sure that we are prepared to recognize that other individuals outside of our own ethnic and religious communities need to have that added protection. And that protection is absolutely mandatory, I think, in the context of the work that religious communities do. The second case that we were involved in was a case called Multani. Gurbaj Singh Multani was a young Sikh boy. And he was faced with an interesting dilemma. As one of the 5 articles of faith that a Sikh keeps on their person at all times once they become confirmed into the religion, that article of faith was a kirpan. And a kirpan resembles a small sword. And Gurbaj Singh Multani was confirmed into Sikhism, and he used to wear this kirpan on his body at all times. That reminds the Sikh, A, of their own mortality, but B, of their obligation and duty to defend the defenseless, to stand up for the rights of those that can't defend themselves. It's never to be used as a weapon, it's never to be used in any form, but the reality is that for an outsider who does not know what this is, it may very well look like a weapon. And so Gurbaj Singh Multani was playing on the school playground. The kirpan fell out, and he was faced with expulsion by the school because they said to him that he could only come to school without the kirpan. So that case ultimately went all the way to the Supreme Court of Canada, and in a unanimous judgment, the Supreme Court of Canada recognized the religious values and principles that really went behind the kirpan and that really were the reason why Mr. Multani was wearing the kirpan and allowed it. But what was really telling, I think, and what goes back to Barry's question that he's asked, the statement that the Supreme Court of Canada made in that decision is, I think, one of the most profound and beautiful statements of not only freedom of religion, but conscience as well. What it means to be a person of faith, what it means not just necessarily to practice a religion, but to have values and beliefs and how those need to be protected. And so, Barry, although I know that you spoke about this concern about whether there's a narrowing or an attack on religious freedoms, I wonder, though, whether, in my view, really, it seems to me that they're being broadened. When people like Mr. Multani can be accepted by the Supreme Court as an individual that has rights to freely practice his faith, when that definition is broadened to include other religious communities, I don't know that there's an assault that's narrowing the definition. But I do think that what's happening is there is a dilemma in the Trinity Western case, and that dilemma falls full square into this issue of how far do we take religious freedoms when they directly impede or affect another community? And, you know, as many of the lawyers in this crowd might know, we're often taught in law school that my right to swing my arm is limited when it strikes your face. And so the question really is how far are religious communities permitted to go outside of the church, outside of the synagogue or the gurdwara or the mosque, and impart either in educational institutions and have students from the public coming into those institutions, and then have rules and requirements that may offend the Charter of Rights and Freedoms or some other human rights types of legislation. And I think, to be fair, in my view, that's the dilemma that the court, or that the legal community is struggling with, and the court will have to struggle with, ultimately in Trinity Western. And I don't know that it's an assault on religion as much as it is going back to this question of viewing the relationship between religion and religious freedoms, really, and social stability. And I really liked what Marco Ventura did in his presentation this morning. He talked about sort of 4 ways to view that relationship. And the first he spoke about was religious freedom is a threat to social stability, or perhaps number 2, that social stability is a threat to religious freedom. Or he said that potentially number 3, religious freedom is indispensable to social stability. And then 4th, that social stability may be indispensable to religious freedom. And so he gave us 4 options. I would beg to differ and say that there's a 5th option, and that 5th option is really that there is an intrinsic interconnectedness between religious freedom and social stability such that neither takes precedence over the other. Both of them require each other absolutely equally in order to build the kind of society that we want to build. And I say that because I think ultimately, if we are looking at, really advancing society to the place that Tim Wilson was speaking about this morning, a society where religious organizations and communities, I think in the 21st century, he said, need to be able to step outside and go beyond, beyond themselves in a way, and in order to be able to advance into the future. I think that's really what we're looking at, which is I cannot have my religious freedoms unless I live in a socially stable enough society that's not threatened by my presence or appearance as a Sikh. So social stability is critical to me being able to have religious freedom. But on the converse as well, religious freedom is critical because if you allow me to freely practice who I am or as I am, then ultimately society will become that much more better for it, because I will be able to participate equally, fairly, contribute to the economy of society, contribute towards building it. And so religious communities, in my view, and I think I'm running out of time, religious communities ultimately, in my view, I think, have to ask themselves the very difficult question of what do we do when the otherness of the other offends our moral values? Do we step back and say our moral values take precedence? For many Sikhs, they're against gay marriage. I don't think that you will see gay marriages occurring in the Gurdwaras, but the Sikh community was upfront in support of same-sex legislation in Canada, because we believed that even though it was uncomfortable, even though for some Sikhs it may even offend their deep moral values, there was a larger, more positive, necessary social outcome that was critical. And that was recognizing that the other ultimately is my brother or my sister, and that they have equal rights. And while I might find their behavior offensive, so long as it doesn't directly impact me or impede me in being able to conduct myself, then I really must be able to stand out and move forward and support in support of them. And so that's my premise. Thank you so much. I appreciate the time.
Well, good afternoon. Thank you for having me. Thank you for having me here, and I'm happy to have this opportunity to speak in this symposium. So I speak in my capacity as an academic, and being the last speaker in a very long day, I think what I want to do here is really just to offer some questions for reflection. And this draws from some of the themes and the claims in my forthcoming book, which is about the history behind the international law on religious freedom. So what is religious freedom good for? Despite being enshrined in international law, the UN Declaration of Human Rights, for instance, and almost all national constitutions, religious freedom, I think, is an endangered right and principle. But not in the obvious way that the people in this room already know. We all know that there's no lack of examples of religious persecution today. Just look at the example of what's happening in the Middle East. So there's also systematic persecution of particular religious communities in Asia and in Africa. But I want to talk about the not so obvious ways that religious freedom is endangered, especially in this age where both extreme belief and extreme unbelief actually coexist. So the first is in the way that religious freedom is framed in efforts by Western governments and groups in order to address these tragedies. So there's an increasing amount of criticism directed towards the promotion of international religious freedom by Western governments, as well as various non-governmental organizations. As we have briefly heard from Professor David Little during his plenary remarks yesterday evening, one main complaint is that the foregrounding of religion as the main explanation for a lot of geopolitical conflicts breeds even more sectarianism or creates conflict where there is little. And the underlying premise of this complaint is a blind spot caused by the dominant secular worldview of many in the West. We know that there's an increase in terms of the number of people who are irreligious, And that's similar in number in terms of domestically and internationally. So in Western societies, such as Canada, where we have the Charter of Rights and Freedoms that protects religious freedom, religious accommodation claims are sometimes seen as unfair exemptions. So one would normally hear the complaint, why can't we all just follow the same rules? Or why can't they just be religious in private? Why consider religion special at all? Internationally, many scholars and even government officials and policymakers also tend to think that religion is simply a proxy for other things and nothing else. For some people, it can be a proxy for some kind of hatred against the lingering colonial presence in the Middle East, for instance, or the simply lack of jobs or civil order in particular societies. And I think that's because religion now is less relevant in our own lives, generally speaking, notwithstanding this conference. The appeal of the terrorist group ISIS, for example, rightly or wrongly, lies in its religious mission and character. But for many people, it's difficult to comprehend, much less to relate with religion's resonance and power for believers, and especially for those who believe that this life, the life in this world, is not all there is to it. Religious freedom presupposes, though, that one is claiming a freedom that is religious in character. And if we take these criticisms to their logical conclusion, and religion is just a smokescreen or a proxy for other values and factors in a particular conflict, we are left with nothing. So what would it mean then to protect religious freedom? Religious freedom is also endangered in another non-obvious sense. If we accept in principle that other countries have a right to promote promote human rights and particularly religious freedom, then we also have to take a look at their justification for doing so. So when you look at the platform of many groups advocating for global religious freedom, you're actually quite hard-pressed to see the reason or rationale behind these particular advocacies, right? So is it really enough to promote religious freedom because it's part of the UN Declaration of Human Rights? I'm not really sure that we should stop at that. I think religious freedom is endangered of being left at the margins and not taken seriously if we don't make it speak to secular interests. So if religious freedom advocacy is undertaken at the exclusion of other important earthly and secular interests, then its advocates, both governments and non-government groups, risk religious freedom's own marginalization in the mainstream discourse as something that is only of concern, for instance, to Christian groups. And in a largely secular West, that's probably the most unfortunate situation to be in. So I have this forthcoming book that tells the history, the United States' involvement in the long history of promoting religious liberty abroad in various places, partly out of genuine concern for the plight of religious believers, but also in recognition of its own national interests. And I think that concern with religious freedom abroad, as well as the creation of institutions that advanced such freedom, has since been copied by countries such as Canada and other European countries. And I think that's for a good reason. If it's just the United States doing that, people could easily perceive that it's simply trying to impose its own values in these other places. But having an international coalition address this important challenge gives it more legitimacy. But as all these countries come together to promote religious freedom, we also have to change the way that we talk about religious freedom. Governments, for instance, should take religion and the language of religion seriously. But at the same time, religion should also take the language of the state seriously. How does religious freedom intersect with other issues relevant to a particular society? And it should be made clear that the pursuit of religious freedom is done not only because it's a human right, although of course it's an important human right, or that it's also the right thing to do, even though it's really the right thing to do, but that it's also in the national interest of these governments to do so, and that it need not be a zero-sum choice between the two. So thank you.
Thank you to each of our panelists, and we have about 15 minutes that we can address questions, or they can address questions. And so if you have, we have a microphone at the back. If you could please stand and identify yourself and direct the question to a specific individual, please.
Brian Lucas, General Secretary of the Catholic Bishops' Conference in Australia. My question is to whoever on the panel is prepared to have a go, and it's the question of how we ground this point of intersection between, to use the example, swinging your arm and hitting someone's face. No one has a right to do what's wrong, that's obvious enough. But it seems to me from the description Barry gave of the university case, there's a mounting public pressure which goes nowhere to deciding what's right or wrong. You know, right is right when everybody's wrong, and wrong's wrong when everybody's wrong, and right's still right when nobody's right. That's clear enough. So how do we decide then the right and wrong to find that point of intersection so that a person chooses to go to a university and chooses to sign a form, but then is denied recognition as a lawyer?
Well, as far as, from my perspective on this matter is that you point out something very interesting, and that is the fact that this is a matter of choice. It is a private university, and a person is able to choose to go. It's not like they're being forced to go, nor is it a situation where an individual who would be opposed to the community covenant would have no option. In fact, they have the options right across the country. What's been happening, in my perspective, unlike Palbinder, we've been debating this back off and on here since we met up with each other here this weekend, which has been a lot of fun. But from my perspective, there's moving of the goalposts, in my view, what's happening. There's the concept of the public. And so it really is kind of like we see the idea that because something is public, therefore the religious institution that's operating in the public must then follow the norms of the public. And the problem is, in my perspective, or from my view, is that public goalpost is now moving. At one point, it seemed very clear that public did not include religious institutions. It was public only in the sense that the government was interested to make sure that the Christian university was properly educating the students so that they would be able to go and receive the imprimatur of the state that says that, yes, this student is properly qualified to go ahead and be involved in the accounting profession, or to be involved in the nursing profession, or to be involved in the teaching profession. And this one is dealing, of course, with the legal profession. What's happened, and I think it's a relatively recent development, is that the idea of the public now is of such a degree that, no, you being involved in a school is now considered public. And even though it's private funded, even though whatever, but because the state receives or because the state gives recognition to that diploma, that now is public. And the problem with that, as far as I see it, is this. There's also further argument developing in amongst the legal community in Canada, is the idea that even charities, a charity that issues a charitable receipt in Canada, when a donor gives money to a charity issues a receipt. That receipt is then able to be used by the donor to reduce the tax payable at the end of the year. And the argument now being made is that that charity is now considered a public entity because it's receiving, in an indirect way, a government support. This is new thinking. This is why I say there is a paradigm shift in the making here. we haven't seen these arguments before. It's new. It's part of this, and I see it as problematic. Now, I just want to mention as well, with your statement there about the fact that you're saying that, well, in Canada, you get a broadening of religious freedom because you got more groups and so forth. And there is definitely an oscillation going on in the jurisprudence. On the one hand, the Sikh community member or the Sikh student was able to receive accommodation for the Kirpan. But not several years later, we had a case at the Supreme Court of Canada with the Hutteran Brethren, who wanted to be exempt from having their picture taken on the driver's license. The Alberta government had given that community 29 years of exemption of not requiring them to have their picture taken on their driver's license. Recently, the Supreme Court, in the Hutteran Brethren case, decided, well, yeah, the Alberta government has given 29 years. Now the Alberta government is saying, no, we want everyone to have their picture taken. And the Supreme Court ruled that this was of such an administrative matter and a concern with security and so forth and all that's going on, we are now going to allow we side with the government and against the religious community. So what I sense happening here is that the court is definitely struggling with trying to find the way here, to follow the way through. So I'm not as optimistic as you are, and I'm really concerned with the changing of the goalpost as to what public is and where that intersection occurs.
If I may, I'd like to address that as well. I think you've touched on several points. The last one I just want to address really quickly. I think, to be fair, Barry, the Hutteran Brethren case is really a part of the trilogy, right? So you have to look at it in the context of Salem, Multani, and the Hutteran Brethren. And all three of those cases were decided by the court in fairly close succession and are considered in Canadian jurisprudence to really be the trilogy of cases on religious freedoms. And so they set the goalposts, certainly, where the Hutteran Brethren requests for accommodation were considered too far, but where the Multani requests were considered not to be too far. And I think it's a question of exactly where do they draw the line. Coming back to your question, I think there's two things that are happening. I absolutely agree with Barry that there's an issue of public and private. And there's no question, and has been no debate, certainly around the Trinity Western case, about whether churches or masjids or synagogues would be forced to perform gay marriages. That's never been on the table. The question has always been, what happens with gay rights outside of the church? So say what you want, believe what you want, but when you start going into the public sphere, where do we draw the line? That's really, I think, what everyone is struggling with. I don't know that it really comes down to political pressure. I do see absolutely that there is certainly some of that happening, particularly the Law Society of British Columbia, where originally they made the decision to allow accreditation for Trinity Western, and then there was an outpouring of a lot of objection by the legal community, and they did a very strange thing. They reconsidered their decision and retracted it and came back with, after a referendum with the legal community in British Columbia, came back and said no, they would not accredit. So in certainly BC, public pressure has played some role. I think it's going down to a different issue, though. I think it's a question of what harm is. So when I'm speaking about swinging your fist and hitting my face, what I'm not talking about necessarily is physical harm. What I'm speaking of is social harm. The social harm that comes to society when we continue to disenfranchise those groups that have been disenfranchised for significant periods of time. And I think right now the two groups that I would say are really at the forefront in Canada, certainly, and around this issue, I would say one is the Muslim community, particularly niqab-wearing Muslim women have borne the brunt, really, in Canada in terms of being a lot of political sort of leverage is being used, with the Prime Minister of Canada saying that their government would appeal a decision by the federal court which allowed a niqab-wearing woman to be able to swear an oath to Canadian citizenship while wearing her niqab, even though she would be identified privately prior to the ceremony itself. And he, in fact, then they went ahead, appealed the decision of the federal court, and today, just about half an hour ago, the decision came down from the Court of Appeal that they weren't going to grant a stay of proceedings and she'd be permitted to go ahead to the swearing-in ceremony. But the public outcry against that woman is enormous. If you were to poll Canadians, a majority of Canadians, not just in Quebec, outside of Quebec, would say that she should not be permitted to swear this oath wearing her niqab. And is it because of a moral, is it because, there's some real security, safety threat? Or is it really because there's something that for many people is deeply offensive about the niqab? And I would say it's the deeply offensive part of it. It was deeply offensive for the Sikh community, so much so to the point that our code of conduct, which doesn't have very many do's and don'ts, but one of them is a woman should never veil her face. It's absolutely prohibited in the Sikh religion for a woman to veil her face, because the idea is that it oppresses women. But yet, we were the only religious community to speak up in support of the niqab-wearing woman, and try to go and make presentations on her behalf at the hearings that were held on this proposed Quebec Charter of Values, to our detriment, because we were banned from going into the National Assembly because our delegation was wearing kirpans. And so, the very article of faith that enjoined us to stand up for her rights was the article of faith that prevented us from being able to speak in her support. That's a scenario where, again, something that is very distasteful, that's morally offensive to me, I still feel a moral obligation, which is greater than the fact that a woman shouldn't have to veil her face, to go forward one step and say, but she should be permitted the right to choose. And who am I to go and enforce upon her my view of the world, my view of morality, my view of what's right and wrong? And I think that's really where I get into this debate of swinging my fist and hitting somebody's face. It's really about what is the social harm that will flow from taking positions where we're really protecting just our own self-interest.
Thanks. This is a question for the whole panel, really. It sort of flows from that conversation. But it seems to me that when we're talking about religion, we can think about the benefits to society for individuals of pursuing their own identity and understanding their relationship with the world and the meaning of their lives. That's one category. But there's obvious benefits in a more material sense to societies, and we're sitting in one of those right now at BYU, of religious freedom, and the obvious benefits in the United States, in Australia and a lot of other jurisdictions of religions can be seen from the schools, hospitals, universities and so on that have been established only purely because of the religious objective of those establishing the organisation. So with the university, it seems to me that, and I'd be interested in your comments about this, the stance which has been taken against the university is depriving those students who wish to learn the law in a context, in a Christian context, from being able to do that. And it's doing that solely for the purposes, it seems, of avoiding some harm which is indeterminate to people who wouldn't be interested in going to that university. So that's the conundrum that I can see with the propositions you've just been putting. So interested in your thoughts and indeed in Anna's thoughts.
Sorry, can I just interject here? We're at the conclusion, so if we could just keep comments to a minute, and then we'll conclude.
I think part of it is that the issue is so complex. It's not simple. It's not a simple question of students being permitted to follow their faith and to learn, which I think is an excellent reason to want to have religious-based institutions. In this case, I think a large part of the objection really was because this is a law school, where the law students have to subsequently swear an oath to uphold the charter. And it was really, and perhaps it's a, sort of a very finite legal distinction, but certainly that's the legal distinction that seems to be paramount concern. I don't think that you would have had the same type of objection to that larger degree had it been for some other, like accountants or something like that. That would be my view on that.
Okay, Barry would like to have a concluding comment too, and then Anna, would you like a concluding comment? And then we'll end. So,
First of all,
30 seconds.
30 seconds. My response to that is that hold on, you know what, let Anna go ahead and I'll
Actually, so just on the point about Trinity Western and the law school, I mean, I agree that part of the apprehension has to do with the law school training lawyers who will be, who are supposedly, who are expected to uphold the values of the charter, equality, dignity, and all that. But I think one has to do it on a case-by-case basis. So as she mentioned, there was a previous case before that involving teachers. And so unless you can actually show that there's some empirical basis that the graduates of this particular school would actually go out into the world and engage in some form of discriminatory practices, or I think it's well within the religious liberty of the religious organization to set up these schools and educational institutions.
Okay, so my response is, first of all, that the concept of lawyers being different than CPA or nursing or the education department, in my view, doesn't hold, in the sense that marriage is, and marriage, traditional marriage, and the principle that TW stands for is, in fact, public policy. It's been recognized by the Civil Marriage Act that it's not against public policy to speak out in favor of marriage. It is also in the Income Tax Act, there was an amendment there as well. So it strikes me that marriage itself is not against public policy. And the other thing is that it's very clear that even the Federation of Law Societies itself, which did an extensive review of this matter, came out and said that the law required Trinity Western to be accredited. So in my view, the argument saying that, well, it's against the law doesn't hold, simply because, well, the law, even the Federation of Law Societies says the law requires this. So anyhow, that's an interesting debate.
Thank you, all three of you. Thank you so much for your presentation and for the great work you're doing. Thank you.